Ghislaine Maxwell is in hot water. Now she's running out of money in addition to all of the other problems that she's facing. So she is now set to sell her home, which she's not living in currently, to afford her attorney's fees, which are, I would expect to be massive. I was on another show, Sean Atwood's show, and we were talking about this, and we were sort of speculating about what her hourly rate for her attorneys might be. And I was saying it could easily be $2,000 an hour. Easily. It could easily be more than that. I'd say I can't imagine in any world where it's less than $1,000 an hour. Spending a ton of money, and her attorneys are doing a ton of work. I mean, a ton. We've gone through the docket here on this show, and you'll notice that like every day they're doing something. They're always communicating with her, so they are racking up a massive bill. And it's funny that we were just talking about it because this story came out today. Now, she may have to sell her home. This came over from the WashingtonExaminer.com. There it is, WashingtonExaminer.com. It says, Ghislaine Maxwell, the British socialite with ties to disgraced pedophile Jeffrey Epstein, will soon be selling her home so she can pay her legal fees, her family spokesperson said. The house is located in London's Belgravia district. The sale will be completed soon, said Brian Basham, spokesman for the family. Houses in the area have sold for the equivalent of between 3.6 and 11.2 million. One of Epstein's accusers, Virginia Roberts Guffrey, alleged that she was forced to have sex with Prince Andrew at this property in 2001 when she was 17. Member of the royal family has disputed the allegations. She's nearing a deal to sell the property despite her bank, Barclays, deciding to close her accounts in February, according to the Wall Street Journal. Her brother, Ian Maxwell, accused the bank of closing her account to protect Barclays CEO Jess Staley, who visited Epstein's private island multiple times when he was an executive at JP Morgan Chase & Co. So you see how deep the hole goes. We have no idea what Staley got up to with Epstein, but whatever it was, it's his problem. And he should not be taking his problems out on my sister. Staley is playing at Pontius Pilate with my sister's life, Ian Maxwell said, though a bank spokesperson rebutted the claim, stating, as a matter of course, the group CEO would not be involved in decisions to close accounts. And so we're going to go through, first of all, that's obviously a big problem for her. If she runs out of money, her attorneys stop working, and that's not good for her. So we are going to take a look now at her the response to her motion to get out of custody. So remember, earlier in February, she submitted her third bail motion, which is a request to get out of court, get out of custody, so that she can get back to preparing her court case. She's tried to get out. She originally submitted a proposition to get out of custody that included massive amounts of collateral, tens of millions of dollars, multiple properties, even giving up her citizenship in France and I think England, amongst other places, forfeiting her passports, saying that she's going to get on an ankle monitor, communicating with people. They even went so far as to appoint a federal or find a former federal, I think, judge and prosecutor to monitor her bank accounts so that she could only withdraw at any given time $5,000. Anything more than that would be subject to oversight from the federal judge, former federal judge, and a former U.S. attorney, a former prosecutor. They're both going to be monitoring this. I mean, this is massive. I mean, this is the type of it's one of the most expansive attempts to get somebody out of custody that I've ever seen, and they're on their third attempt now. Trying again. So they submitted that prior request. The government is now responding to this, and they're saying, no, you're not going to get out. Here she is. This is from electronic mail, electronic court filing, document 165. This was filed a couple days ago, March 9th. And it says here, Dear Judge Nathan, the government, I'm not going to read all of this. There's a lot of text in this, but we're just going to kind of skim through it. The government respectfully submits this letter in opposition to the defendant's number three, motion for bail that was submitted back on February 23rd. We've had extensive briefings. We know that she poses a serious flight risk and that no condition or combination will secure her appearance in court. They're saying if we let her out, she's gone. There's no way we're going to get her back in court. Doesn't matter what she promises. Doesn't matter if she gives you the house, gives her the passports, whatever. If she steps foot out of this prison, she's gone with the wind. On December 28th, after the defendant renewed her first motion by restating her prior arguments and giving a more significant and specific bail package, this court concluded she plainly poses a flight risk and denied the release. They appealed again in 2020. Now they ask a court yet again to consider its decision. They proposed 2 additional bail conditions to supplement the bail package previously considered and rejected. For the reasons set forth below, should be denied. Number 1, why should it be denied? The court does not have jurisdiction to grant the third bail motion. The defendant has appealed that December opinion to the second court. So they're talking about, which I didn't even realize that they appealed that. That's insane. They're talking about the fact that because that second motion is being appealed, that this court can't consider any current pending motions until that other matter is resolved. We sort of saw this issue in the Chauvin case that we've also been talking about. That third-degree murder charge was appealed. Both sides didn't want the trial to continue because the court really didn't have jurisdiction until it came back down. Judge went ahead anyways, and then they got that stuff sorted out. So the prosecutor here is also saying, no, we can't even argue this, can't even decide on this because they're already appealing attempt number 2 up to the Court of Appeals. Second, even assuming that this court had jurisdiction to grant the latest bail application, the court should adhere to its prior rulings because she continues to pose an extreme risk of flight, and the additional bail conditions do not justify the reversal. So they're saying this should be denied. A little bit of background here. Court's document in December 16, 2020. Court originally denied it. They submitted a substantially larger bail package. Court denied that. January 11th, they filed a notice of appeal to the Second Circuit. February 23rd, then, about a month later, over a month later, they submitted the third bail motion package. And here's what they wanted to do. They wanted a renunciation of the defendant's French and British citizenship. So she's going to give up those passports and the citizenship entirely. And I'm going to show you, we actually have a statement from the French that detail how this works in their country that was attached as an exhibit to this motion. Number 2, they want to place a portion of her and her spouse's assets that are overseen by an asset monitor. So that was the two individuals that I was talking about that are going to oversee all of her assets. They're going to dump everything, all of the assets from all over the place into one bucket, and they're going to put a couple people in charge of monitoring that. The court, as they said, does not have jurisdiction to grant the third bail motion. So you can see a lot of this stuff is just sort of law as a general matter, the filing of notice, blah, blah, blah. This is all procedural stuff, a lot of case law here, stuff that's not particularly interesting, but we can just kind of skim through this. Then we go on, subsection number 3, the court should not reverse its prior well-reasoned and thorough bail decisions. Even if this court had jurisdiction to grant the bail motion, the motion should be denied. Court has already twice made the determination that the defendant poses a risk of flight. In particular, the court has found that the charges carry a presumption of detention and are serious and carry lengthy terms of imprisonment if convicted. The evidence proffered by the government, including multiple corroborating and corroborated witnesses, is strong. Defendant has substantial resources and foreign ties, including citizenship in a country that does not extradite its citizens, and the defendant, who lived in hiding and apart from the family to whom she now asserts important ties, has not been fully candid about her financial situation. So yeah, this has been something that has been interesting, right? She was already in hiding for a long period of time. And one of the principal arguments that was in her underlying third motion was my husband and my family, and I want to get connected with all of these people, but I can't because I'm in custody. And that's something that's pretty common, but the prosecutor here, I think, is rightfully pointing out, well, you didn't care about him before you got taken into custody, so why do you care about him so much now? In seeking bail for a third time, the defendant's motion rests principally on 2 additional bail conditions. Neither of these conditions, and those 2 conditions were, of course, giving up her citizenship and dumping the assets into a monitored bucket. Neither of these conditions will reasonably assure her appearance in court. Neither outweighs all of the other factors. Moreover, the court should reject as premature the assertion that her pretrial motions have weakened the government's case. The motions have not been adjudicated, and thus the reasons set forth in the opposition memorandum, the defendant's motion, have no merit. In short, all 3 of the relevant Bail Reform Act factors, the nature of the offense, the strength of the evidence, and the history and the characteristics of the defendant continue to weigh heavily in favor of detention, and the defendant's motion does not present any information that warrants a revisiting of the well-reasoned and detailed prior decisions. So let's take a look. This is a long opinion. Let's take a look if there's anything else worth covering. We have the applicable law, so they're going to tell us what the law is. We got that. Defendant's motions rest on 3 arguments. Renounce the foreign citizenship, claiming that this eliminates the risk that she will flee from prosecution. Second, offers to place some of her assets in a monitorship. And third, claims that her pretrial motions have diminished the strength of the government's case. So let's take a look at each one of those. Here we have the defendant's willingness to renounce her foreign citizenship. So what if she does give it up? She contends that she has materially strengthened her proposed bail package by offering to renounce her foreign citizenship if the court so requires. She claims that such a renunciation will eliminate any opportunity for her to seek refuge in France and the UK, or remove any incentive the court and government believe she may have to seek refuge in those countries. The defendant is wrong. That she is, quote, willing to renounce her citizenship would do nothing to prevent her from fleeing and fighting extradition once abroad. It does nothing to diminish the risk that the defendant could choose to flee to another jurisdiction altogether, including one with which the United States does not have an extradition treaty and from which extradition is impossible. The court previously found the likelihood that the defendant would be able to frustrate any extradition requests weighs strongly in favor of detention. Motion provides no basis for disturbing that finding. We go on to number 3. The willingness to renounce the citizenship is an offer with unclear validity. We're going to talk about that. The defendants have offered no authority for the proposition of her renouncing foreign citizenship, whether that would have any impact on the extradition proceeding. So they don't even know if she can do it. They don't even know that if she did in fact renounce her citizenship, whether that would ultimately preclude them from not extraditing her. And so let's go through that. Here is subsection 2. They should reject the proposed monitorship condition. So this is the monitoring of the bank account. They're saying that she's going to place a portion of her and her spouse's assets into a new account that will be monitored by a retired federal district court judge and a former U.S. attorney who will function as the asset monitor. They're going to have co-signing authority over the account. The proposed condition, the details of which are vague, is insufficient to assure that she appears in court. So do you think that she really would include all of her assets, everything, into this bucket, truthfully? Does she have anybody else who might be able to lend her $1 million in order to escape the country? I have a hard time believing that everything would go in there. And lastly, we have the defendant's pending pretrial motions have not diminished the strength of the government's case. So this is based around the idea that they're saying that they've been doing a lot of work on the case. They've been submitting motions after motions after motions, and that is going to weaken the case such that this justifies her, supports actually a not guilty verdict, right? It supports that there is no likelihood of criminal conviction here, which, of course, if they have a weak case, then that goes against the elements of holding somebody in custody. It goes against the nature and the context surrounding the underlying offense. And so they're saying because the case is getting weaker, there's sort of an inverse relationship there. The stronger the case, the less likelihood of her getting out. But if the case is weaker, then there should be a stronger likelihood of her getting out. The government just says, no, that's not we're not going to do that. It says here, numerous substantive pretrial motions now before the court amply challenge the purported strength of the government's case, but they cannot merely point to the sheer volume of briefings that she has filed to suggest the strengths has been diminished. And so the prosecutor even knows this. I've been saying it. I've been saying that they have been filing a ton of stuff, and they're pointing this. Merely the sheer volume of the briefings, that doesn't mean anything. To the contrary, the government has set forth in detail in its memorandum the pretrial motions are entirely without merit. In any event, it's premature for the defendant to claim that her pretrial motions, which have not been adjudicated, have altered the court's original determination that the government's case is strong. Signed here by Maureen Comey, Allison Moe, Laura Pomerantz, all out of the Southern District of New York. And so I think that the deadline for Ghislaine and her attorneys to reply. So remember, you file a motion, you get a response, and then the moving party gets to reply to the response, and that's the end of the conversation. And so I think their reply is due by Monday. If I can, I might be off on that, but it's coming soon. And so next week, we're probably going to see a ruling on this third bail attempt. I do not think that it is going to go Ghislaine's way. This is kind of an interesting case because truly, we talked about this yesterday with Chauvin. And we talked about this yesterday with maybe not yesterday, but previously in the week about Jacob Chansley, who is the QAnon shaman who is not being granted bail either. He's got no criminal record. The judge was talking about him using drugs as evidence of criminality. The judge also said that because he committed a crime that he's being held for, that fact alone makes it likely that he's going to commit another crime, something like that. Asinine opinion, one of the worst opinions I've read recently from a judge in a federal court like that, but whatever. And it's an interesting thing here because we were talking about this on Clubhouse last night. We were saying that, well, Rittenhouse got out of custody. He had a $2 million bond. Chauvin got out of custody. He had a $1 million bond. Other murderers get out of custody. Ghislaine Maxwell didn't murder anybody that we know of, right? Some sexual assault crimes. Okay. Heinous, horrendous, awful, reprehensible conduct, but other people got out of custody and they killed somebody. Why wouldn't she get out of custody? Well, maybe she should. Maybe the factors support legally her getting out of custody if you compare it to other defendants who have been similarly situated. But if I were the judge, I don't care what the law says, right? You go through and you do your analysis, and she does not get out of custody regardless of anything, because of the simple fact that the risk of her flight is so high, so massively high, that basically anything that they propose, I don't think the judge is going to consider that at all. So here is the last little bit from France. So this is what they say. So they sent a letter over there. This is the Ministry of Justice, the Directorate of Criminal Affairs and Pardons. This comes from Paris, March 9th. His Honor and Keeper of Seals, the Minister of Justice, which is pretty awesome. A Keeper of Seals. Sounds like something out of a fantasy novel. From the Department of Justice, says, I hereby inform you that in France, all removal proceedings and conditions are governed by Article 696 of the Code of Criminal Procedure. That code provides the French government is able to remit to foreign governments upon their request any individual who is not a French citizen, who is subject to a lawsuit brought on behalf of the requesting state, and who is subject to a sentence passed by the court of said requesting state, and who is located on the territory of the French Republic. So if you are not a citizen, we're going to wrap you up and you can go. We're going to send you overseas. However, Article 694-4 expressly specifies as follows: removal is not granted when the individual claimed to have French citizenship, said citizenship having been assessed at the time of the offense on the basis of which removal is being requested. Removal is not granted for that. And so citizenship having been assessed at the time of the offense. Well, she had citizenship at that time. She has citizenship now. She hasn't given it up yet. So she's had it at the time of the offense on the basis of which removal is requested, whereby the fact that the wanted individual is a French national constitutes an insuperable obstacle to his or her removal. As long as said nationality is assessed at the time of the offense was committed, any loss of nationality subsequent to said offense has no bearing upon the removal proceedings and shall not supersede the said assessment of nationality signed off by Philippe, head of the International Criminal Assistance Bureau. So what they said is, if she was not a citizen, we'd send her right back. But she was a citizen at the time, therefore, we're not sending her back, even if she renounces her citizenship now. Sorry, we're going to consider it at the time of the offense. So if she left and fled to France, according to their own specialized criminal justice subdirectorate, Philippe something, she doesn't come back to the States. So this judge is not going to let her out of custody. We have some questions coming in from locals.com on our Watching the Watchers group. Says Paula MK, if Maxwell is selling because she's running out of money, how does she expect to use all of that collateral as bail? Also, is this a ploy to get out of saying that she no longer has the means to flee because she's supposedly running out of money? Yeah, probably. I mean, I think this is probably theater, right? If Epstein was worth several $100 million, a lot of that money still floating around. I'm sure she's got access to mounds of cash. And this is a nice little liquidation of certain assets in order to accumulate those assets that she can expend towards her legal fees. But does anybody really think that she doesn't have access to millions of dollars? I don't. We have News Now Wyoming. Last question of the day says, Rob, do you think if she hadn't made them search for her when they arrested her, that would have changed her chances for bail? If I remember right, it took them a while to locate her after the warrant was issued. Yeah, it actually might have, right? If she knew, as soon as she knew that they were looking for her, if she just hired an attorney and said, all right, look, make contact with them, negotiate some bail conditions, negotiate release conditions for me, she might have been able to negotiate those things out. And I don't know if she did that. I don't know if her attorneys attempted to do that or what the underlying investigation looked like that ultimately led to her capture. But certainly, one of the things that judges look disfavorably upon is when you are fleeing formal court process, when you're fleeing being served, when the court has summoned you to be a part of the process and you just leave. Court does not like that. Not at all. And here, because she was running around the country, sort of in hiding for a long period of time, the judge may look at that and say, no, you were not forthcoming. You're saying now that you're going to come back to court, but you didn't at the first time. So how are we supposed to believe you? And I know you're going to give up all this stuff, but do you think that we believe that you don't have any assets to get out of the country? And you said you'd give up your French citizenship, but the French don't even say that that matters. So I think the judge is just going to deny this one again, and she's going to remain in custody. But as you can see, they are filing these motions, in my opinion, to set a very strong foundation of appealable issues. They're going to say that because she was in custody, as you can see, they're already appealing this to the to the Court of Appeals. If they don't let her out of custody, they're going to make all sorts of due process claims, all sorts of procedural violations, that she doesn't have the opportunity to consult with her attorneys enough, that she's getting treated inappropriately, sort of almost an equal protection claim, that other prisoners are treated one way. She's being treated differently because of the severity of her claims. And so they're just laying the foundation for this stuff, that when she goes to trial and gets convicted, everything's going to get appealed again. And they want to get her out of custody so that, well, she's not in custody. What happens after that, who knows? But I wouldn't hold my breath on her getting out anytime soon. I think that's the right call. All right, so those questions came over from locals.com/watchingthewatchers. Want to thank those of you who have shown your tremendous support for the show. Big thanks to Miss Faith Joy and to Ma Fox in the house. Thank you both. We've got Liberty or Death who chimed in today, along with Miss Liberty or Death. Good to see you both. Thanks for being here. Jen McClellan. We got Saline Sal. Who else did we have chiming in? We got Scuba Babe. We got Chairman of the Board. Sharon Quidney was in the house. Saw her today. We got Chris Wiseman usually in the house. We got Danny Girl, Realtor Patty. Where's Paula MK? There's Paula MK. We've got The Mariner. We have Britt Reed, Moleface. We have Abby Lou Jack. We have Echo House. We got Get Some Skates, See the Veil. We also have Bumalicket. I like to say that one. We got Nord Sven. Then we have a new individual who joined the group over here. Welcome, Bulletproof number 7. Great to have you. Yesterday, we had some other people sign up. Jared Harding, E2The. We had Danger Mouse Girl. We've got Phantasmagloria. We got Remark number 2. We have Norovira in the house. At Zuck. Zuck's in here as well. And if you're not on Locals, well, what the heck are you doing? We're having a good time over there. There's a lot of stuff you can get as well. Get a copy of my book. It's called Beginning to Winning, How to Fight Your Case and Succeed in the Criminal Justice System. There's a free download in PDF version over there if you want to grab a copy of that. We're also going to post a copy of all the slides there. A copy of the impeachment party documents are there. Grab my existence system if you want it. Free little template here that you can use and make your own personal productivity system that I use every single day. We have links that we share throughout the day, and there's great people who are there as well. We are going to start posting clips of the show over there. You may have seen that this afternoon. Locals is telling us that they want us to post our content there. Well, why? Because they're building some cool features in terms of playlists and some sort of a TV broadcast applications that you can use to play your content elsewhere on your devices and on your TV. So you're going to start to see some content being posted there. If you don't like the notifications, just go into your settings, turn those off, and you won't get bothered so much. I sort of detest endless notifications. So just giving you that warning. We're not going to try to notify you or spam you if you remember over there, but just keep in mind that we're doing that for the long-term building of something better that Locals is going to be unveiling further down the road. So great little platform, a lot of fun people over there. It's at watchingthewatchers.locals.com. You can support the show, meet some great people, and have some fun. All right, so that's it from me. Lastly, but not leastly, I want to tell you that I am a criminal defense attorney, as you can see right here at the R&R Law Group. We are a criminal defense law firm. That's all that we do. We love to help good people who have been charged with crimes find safety, clarity, and hope in their cases, but beyond that, in their lives. We help people who've been charged with anything and everything. Things like even traffic violations, but things like DUIs, domestic violence, disorderly conducts, assaults, urinating in public. Sometimes it happens, and we help people through that. So if you know anybody who has been charged with a crime in the state of Arizona, we would love a referral from you. We'll make sure that we help them, that they come to our office and leave better than when they came. And we got a great team of people. We offer free case evaluations. And so a referral from you would mean the world to us. That is it from me. We are going, any other last minute show notes? Nope. We are going to hop on Clubhouse here for a little bit. So the link is in the description below. Come on and join us. Otherwise, I will see you next week. We'll be back here. I think it's the same time for most of you. We have daylight saving. I got corrected that there's no S at the end of that. Daylight saving time. I think that's starting this weekend. So I think it's the same for everybody, but I think I'm starting earlier on Monday. So I think for me on Monday, It's going to be 4 p.m. Arizona time, 4 p.m. California time, still 6 p.m. in Texas. We're going to figure it out. We'll let you know. We'll let you know. Faith is typing it right now. All right. She's notifying me about what the times look like. So 4 p.m. Arizona time, which means it's going to be, I think, the same for everybody else. So you don't have to change anything, but we got to change. It's the worst. Why did we do this? It's still 7 p.m. Eastern time. It's still going to be 6 p.m. Central time, 4 p.m. on the West Coast. Ugh, gosh. Can we just get rid of this thing already? All right. So that's it for me, everybody. I'm going to see you next week when I see you. Same time for most of you. I'm struggling today. We're going to get out of here. We're going to jump over to Clubhouse. Everybody have a wonderful, very nice weekend. Sleep well. Eat a lot of good food. Unplug from politics. Be with loved ones. I'll see you right back here. Same time, I think. Same place on Monday. Have an awesome weekend, everybody. And bye-bye.